The torts professional responsibility crossover question from February of 2000 will offer some interesting lessons. It's testing some fairly conventional issues in rather unconventional ways. Also, professional responsibility is the most common crossover topic. So we're having a look at it now, even though professional responsibility isn't scheduled for a long time, and crossover questions for an even longer time. Take a look at the call of the question. 1. Were each of the trial court's rulings correct? Discuss. We will isolate each one of those rulings, and we will pass judgment on it after we do some analysis. Call number 2. What, if any, ethical issues arise as a result of the terms under which attorney undertook to assist Lee and reporter? Discuss. Here again, we've got a call of the question that we will organize based on the facts. We don't know enough up front to be able to organize a response to the second call. Now let's go to the top and have a look at the fact pattern. Lee has been a party in a bench trial in front of Judge Bright, and he's unhappy because he lost. After the trial was over, he holds a press conference, and he vents his spleen at Judge Bright in the indented paragraph. And as someone who has conducted a fair number of trials, both jury trials and bench trials, I can understand the feelings of this litigant. Okay, he says that the judge was unfair. He says the court didn't understand what was happening, and he has heard that the judge often is drunk on the bench. Well, our snap response is the first two statements may well be legitimate expressions of opinion, accurate or not, but the last statement likely is going to be considered defamatory. Take a look at what happens next. The remarks are published verbatim in a local newspaper. Judge Bright loses her re-election bid and then sues Lee and reporter for defamation, alleging that he lost the election because of the publication of these remarks. Well, if they don't tell us a lot more about this action, I don't think this single fact is something that we can rely on to reach a certain result in an election or a trial. Both defendants moved to dismiss on the grounds that the cause of action for defamation hasn't been stated, and the motion's dismissed, and I think correctly so. And the comment about potential alleged drunkenness on the bench is enough to keep this case alive. In the next paragraph, after the indented paragraph, attorney offers to act as a consultant to Lee and reporter. Now let's look carefully at what he agrees to do, because that's the second call of the question. Attorney agrees to advise them on law and strategy and to help them prepare their case and get expert witnesses. He also offers to be an expert witness, but says he won't be their lawyer at the actual trial. Lee and reporter both agree to hire attorney and to pay him for his services, both as a consultant and as an expert witness, a contingency fee based on the outcome of the case. Well, we will do a lot of careful analysis, but people who are not doing legal work on a case are not supposed to be paid on a contingency. Now, in the last paragraph, we get the court's rulings, the ones that we're supposed to discuss in our answer to the first call of the question. 1. That Lee's statements about Judge Bright were not defamatory. That's a fairly dicey court holding. B. That in any event, both Lee's statements and reporters' publication of the statements were privileged. Again, we're going to have to look carefully, but I think that this also may be a somewhat problematic ruling. And then C, as a matter of law, Judge Bright didn't suffer any damages. Another one that we're going to have to think about fairly carefully before we are too quick to agree. Well, turn the page and have a look at the outline of issues that I've written to answer this fairly hard fact pattern. And I think you'll see I keep it simple, and I follow the basic approach that I've suggested earlier. With regard to an answer to the first call of the question, I use excerpts of the actual quote for headings. Judge Bright is a very unfair judge. He clearly didn't understand what was going on. I've heard he's often drunk on the bench. Okay, those are pretty good headings, and our analysis will have to focus on the court's rulings. You'll see how I do it in a moment. 2. The court's ruling that both Lee's statements and the reporter's publication were privileged. Here, I don't see any reason to to do any further internal headings beyond talking first about the statements of Lee and secondly about the publication by reporter. Next, we turn to the issue of damages. And here, I have no internal organization to offer. I view this as a straight short answer question posed to us by the examiners. I will give the examiners a straight short answer to that question. Then finally, the ethics call of the question. This one's a little bit more complicated because we have to examine carefully everything that the attorney does and everything he put in the agreement. This is a nice little hint about how we're going to approach PR down the road. The basic approach is organize around ethical duties, or organize chronologically around the facts. Here's an example of organizing around the facts. First, the attorney as a consultant. Second, the attorney as an expert witness but not trial lawyer. And then third, the contingent fee issue. And then finally, a global conclusion about the ethics questions that were raised. Okay, it's a fairly simple question as far as organization goes for a fairly complicated question. So now let's turn and have a look at my answer for a few minutes. You're going to see a couple of ideas that are worth your consideration. Take a look at what I do up front. Here, I lead with the facts in the very first paragraph. I set up the analysis by indicating what's already happened. Next, I define defamation in about as concise a way as one could. We're not getting points for reciting boilerplate definitions. We're getting points for doing factual analysis. Clearly, that analysis has got to be based on the law. So, every so often, I will throw in a brief definition. But now we get to the meat of our analysis, which is focusing on the statements. First, the statement that Judge Bright is a very unfair judge. Obviously, that's a critical statement, but the court was right in ruling that this was not a defamatory statement. It's a matter of opinion, and we're entitled to express our opinion pursuant to the First Amendment to the U.S. Constitution. So, here, as elsewhere, on California Essays, when defamation is tested, the First Amendment almost always is going to be in the background. Next, we consider the judge's ruling on the statement that the judge clearly didn't understand what was going on. This may be an even more serious criticism of the judge than the first statement. This one is not questioning his impartiality, but his fundamental competence. But, again, the statement isn't defamatory, but instead is a mere statement of opinion. It's a little word to the wise. Anytime you want to belittle something, call it a mere whatever it is. The bottom line here, again, is that the trial court was correct in holding that the second statement was not defamatory. Then we reach the final statement that the speaker has often heard that the judge is drunk on the bench. And here we have to focus on whether or not the statement is true. If the statement is true, it is not defamatory. If it's false, it could be considered a per se defamatory statement, which would make it unnecessary for the judge to show that he had sustained any damages. So I conclude that the court's rulings were correct as to the first two statements, but the third statement, if untrue, should have been held defamatory. Next, we turn to the court's ruling that both Lee's statements and reporters' publication of the statements were privileged. Here I focus on the First Amendment up front, and then I move on to consider the two issues, Lee's statements and reporters' publication. It seems to me that the first two statements made by Lee probably are privileged because they're an expression of opinion, and certainly all of them would have been privileged had they been made during litigation from the witness stand. But it seems to me that just because this judge is a public figure does not make Lee privileged to say anything he wants. So with regard to the allegation of drunkenness, here I think it's a much closer call, and almost certainly that statement wasn't privileged. Next, we focus on the reporter's publication of the statements that were made. And here, the plaintiff has an even bigger problem because of the Sullivan versus New York Times and other related cases. These cases you need not cite, but you are welcome to cite them if you know them. And by the way, I think everybody ought to know the New York Times case. Now, once again, we focus on the third statement, and we've got to assume for a moment that it isn't true. Assuming it's untrue, would it be reasonable to find the reporter to have acted with some reckless disregard for the truth? I think the answer is no, and therefore the court correctly ruled that reporter's publication of the statements made in the press conference, in fact, was privileged. Now we focus on the ruling with regard to the judge suffering damages. Here, I lead with the facts. I indicate that the judge lost his bid for re-election after the publication. The election defeat probably is why the judge is filing this lawsuit. Now, I indicate that the statement about drunkenness is a per se defamation, and that means that general damages would be presumed. We've already concluded that the judge was wrong in holding that this statement was not defamatory. So we would follow through the thread of that conclusion to this analysis, and we'd conclude that the trial judge was wrong on this damages issue. Plus, the judge should be able to seek punitive damages because defamation is an intentional tort. Now, let's just pause for a moment. Do you see how the subject of remedies really is at the heart of torts? I'm going to be harping on this topic throughout our work together. I think remedies is the most important subject on the California bar or any other bar, and the reason it's so important is because remedies issues allow us to establish what the parties are entitled to. So, this analysis here in Part 3, although concise, I think you would have to agree is fairly deep, and to the extent it can be said about any bar exam essay analysis, maybe even a little profound. Now, it looks to me as if the judge probably wouldn't have won this election but for the publication of the reporter's story. If he can prove this fact, he'd be entitled to compensatory damages, but I think it's a stretch. Finally, we turn to the ethics issues, and I think you'll see the earlier section is perhaps a little more complicated than it might have appeared initially on its face. Here, we're doing very straightforward analysis, and we're using the facts to organize our approach. So, first we consider the attorney acting as a consultant. There's nothing wrong about this. It doesn't run afoul of ethics concerns. But, if we conclude that the attorney is a consulting lawyer, then all of the attorney professional responsibility duties would apply. It looks as if the two parties, Lee and reporter, have similar interests. There's a potential conflict of interest, and I think it needs to be discussed and acknowledged in writing. Next, the attorney as an expert witness, but not a trial lawyer. Again, there's nothing inherently wrong with this. Lawyers can be expert witnesses, and it's not uncommon for that to happen. The problem is compensation, not the fact that the attorney will act as an expert witness. And then we focus on that compensation issue next. A contingent fee is proposed for this arrangement based on the outcome of the case. Now, it's okay for lawyers to get paid based on results, but expert witnesses can't be compensated this way. Also, we don't know if this fee agreement was reduced to a writing. It should be, if it's worth more than $1,000. It also ought to set forth what percentage the attorney gets, what expenses the parties are responsible for, and recite the fact that the fees are negotiable. This is a little bit of detail about legal fees that you ought to know. And if you don't know it now, we're probably going to touch on it again when we get to PR. So I reach a final conclusion. It's worth noting that the trial court made every ruling in favor of Lee and reporter. So it looks as if the attorney's work as a consultant and expert witness has been successful. Attorney is subject to discipline for performing expert witness services on a contingent basis. And if the agreement isn't in writing, there may be disciplinary problems arising from that fact also. So that wraps up a consideration of a tricky question. We've had issues of defamation and other questions in this seminar, but these are presented in a novel format. Also, we get a glimpse into professional responsibility and crossover action.